Warm greetings, everyone. On behalf of W4W Foundation, a think tank instituted as Citizens Collective, we welcome you to another session of Wednesdays for Water. The conversation today is on water as commons, looking at the policy and law dimensions of it. The objective of Wednesdays for Water is to engage in conversation with water experts, grassroots practitioners, policymakers, young enthusiasts to explore the complex intertwined issues associated with water and the possible solutions they are working on or seeking upon. Wednesdays for Water has expanded since then to have more activities like the Friday Waters and the Monday Munching and Musing with Women for Water, besides organizing on-site water workshops, water walks and talks, seminars, special courses, and conference panels to continue the water conversation in various possible ways. At W4W, we strongly believe that water conversations is the only way towards water conservation. In today's session on water as commons, law and policy dimensions, we have Professor Philippe Cullet and Professor Sachin Warghade as speakers. I met them actually recently in a commons conference we had at ISER Pune, hosted by FES. Today, we also have Vaishnavi Akila as our discussant, and she's returning to Wednesdays for Water again. And welcome back, Vaishnavi. And thanks a lot, Philip and Sachin, for agreeing to do this conversation. Before I invite, let me just go through a brief introduction of each of you. And before that, my name is Mansee Bal Bhargava, and I'm also the host and moderator for today's session. And I'm going to take you through the journey of these speakers and the conversation that will follow up after the speakers have made their presentation. So we will start with Dr. Philippe Cullet. Dr. Philippe Cullet is a visiting professor at the National Law University, Delhi, and professor of international and environmental law at the SOAS University of London. He works on different aspects of water policy and law. He's also the author of Water Law, Poverty and Development, Water Law Reforms in India, and editor of a forthcoming book on river rejuvenation and river rights, Evolving Debates in India. He was a member of Government of India, Ministry of Water Resources, River Development and Ganga Rejuvenation Committee, drafting the draft National Water Framework Bill 2016. I mean, these are, experts with long biography, but I'll keep it short here and invite Philip to make his presentation. And once your presentation is over, I'll then invite Sachin with his biography. Over to you, Philip, and thank you so much for agreeing to do this presentation. You know the format already, so over to you.
Thank you very much for your invitation. And in the few minutes that I have to discuss law and policy dimensions of water as commons, I'll just pick up on a few dimensions that hopefully can lead us to the discussion afterwards. So the starting point is water as a commons has been the framework and the framing that most people have had for water for many centuries. But that's been for the good reasons that life is survival, human survival is survival for nature, its basic needs, it's all of that. It's also for the slightly less interesting reason that it's been difficult and it remains difficult to physically appropriate water in the same way that other natural resources such as minerals can be appropriated. So the fluidity of water, in a sense, has been positive from the point of view of keeping an understanding of water as something that cannot be owned, but it's not necessarily for the positive reasons that we may hope for in terms of the broader social and environmental understanding. Now, so on the one hand, there's been an understanding of water as a commons. On the other hand, because water has been so important, not just for survival and basic needs, but also for running economies, running countries for as long as humankind has been organized in societies, both the state and individuals have sought as much control and appropriation over water as they could have. So in a sense, what we have today as a framing, and that's true in India, that's true in most countries of the world, there is an understanding of water as something that cannot be owned. And within that, there are different forms of appropriation that the state and individuals have managed to carve out for themselves over time. And these are things that really have been carved out over time. It's not something that just happened at one specific point in time. I'll divide the forms of appropriation into individual and state to try and keep it simple and short. So first, in terms of individual appropriation, what we essentially have is so-called use rights. So there is, in principle, no ownership of water by individuals and only use rights. Now, within that dichotomy, what judges progressively did was to develop a set of rights of use for individuals, and essentially these individuals being landowners only, that we know as riparian rights. So it's the idea that if you're lucky enough to be a landowner and there is a stream, a river passing by your land or passing through your land, there are certain rights that you can avail in terms of making use, either consumptive use or non-consumptive use of the river. Now, first implication of this is that if you're a landowner, but you're not lucky enough to be next to a river, you're not a riparian, and therefore you don't have access to those kind of rights. If you're landless, you're completely outside of the framing of these rights. So what we have to immediately understand is that whatever kind of individual rights have developed over time, they've been very specific, then they have not been universal rights in the same way that, let's say, the fundamental human right to water is universal. Now, the reason why these rights have been attached to land is, again, the fluidity of water. That idea is that we would like to introduce property rights. We cannot because we have that prohibition of ownership, but also we don't know how to frame property rights for water in the same way as we are used, again, in that long-term perspective. And the result is that in principle, these rights are an exception to the principle of non-ownership. But if you look at it in practice, that's not how it looks like. To make it a bit clearer, I'm just using another slide to talk about groundwater. So what I was talking about in the previous slide is surface water. For groundwater, these rules, which were introduced in the 19th century, are framed around a limited understanding of the connections between surface and groundwater. And essentially that led the judges who set these rules to say that we're still not going to give you landowners absolute ownership of groundwater, but essentially we'll let you use it the way you want without any limitations. And the problems arising with a scheme like this can be illustrated. For instance, there are lots of other cases, but one that maybe some people already know is the Plachimada controversy, where a bottling plant of the Coca-Cola company, situated on a plot leased that is surrounded by largely agricultural fields, leads to a situation where the aquifer is depleted by the bottling plant. That leads to a conflict. That conflict is taken to court. Okay, the conflict is not only about groundwater, but groundwater was one of the central issues. The conflict goes to court, where in two separate decisions of the Kerala High Court, the first judge says clearly the system doesn't work. Groundwater needs to be considered as a commons. And the second bench that looks at the issue on appeal says, no, it's fine. We can't change the existing system. At most, what we'll do is that we'll recognize that there has to be a limit on the amount of water that any given landowner can take from the aquifer. So that went to the Supreme Court. There was no resolution at that level because it was deemed a closed case, since the company had not restarted the bottling plant operations in the meantime. Hence, we don't have any new understanding of these rules, which also means that these old rules that have been in place since the 19th century have not changed, despite, for instance, here, the vast increase in the use of groundwater and the importance of groundwater as a source of drinking water for most people, which we estimate being 80%. Second, we have questions around state control and appropriation of water. essentially the state has managed to appropriate for itself near absolute control over water, despite the recognition that there is a commons dimension somewhere. In water legislation, which specifically is found in irrigation legislation, but that's a shortcut to say water generally, we have that specifically from 1931 onwards, where we have statements like the one I've put here, where the water vests in the government. This is not a pre-independence only statement. For instance, the 1987 Bihar Irrigation Act still has exactly the same framework. So, and that's still an act which is in place at present. So that's the assertion of control over water. Then there is also the assertion of the power of eminent domain, which is to essentially take away private rights for public purpose, which is most directly reflected in terms of land acquisition, which you'll say is not water, but in the first place, the old legislation of 1894 was largely related to irrigation canals, and even the new 2013 Act still has specific mentions of project for water harvesting and water conservation, for instance, among the reasons that can be given as a public purpose for acquiring the land. So, and because of what I mentioned before, which is that riparian rights or use rights for water are linked to the land. Land acquisition includes the rights to the water as well, whatever rights have been given. To confirm that there is really something like an absolute control over water, there is, for instance, this case of 2004, where the Supreme Court, in a dispute concerning customary rights dispute, told us very clearly that the state is a sovereign dominant owner of water and there is nothing else to discuss. So clearly we're very far from the idea of water as a commons here. What more is there to say? Well, over the past couple of decades, as part of the environmental movement, as part of a broader understanding of what it means to develop and the impact on water and the environment, there has been some significant change. However, before going there, there's two different things to look at. From a water law perspective, there's been a lot of change over the past 5 decades, but most water laws adopted by states, since water is a state subject, still focus on use and allocation to different users. There's very little that's changed, so no real commons perspective coming in. On the contrary, there's been a push in certain forms towards privatization, which implies new private rights, up to, for instance, and that's just one example and one maybe specific example of the attempts to privatize or to lease a stretch of river to a private company. If there is anything which we are made to understand cannot be given into private ownership, it is a river, which really falls under the principle of no ownership. Yet in the environmental discourse, there's been the understanding that we need to move towards something else. And this is best reflected in terms of the developments that we have through the Supreme Court and High Court, as in through the higher judiciary, with the introduction of the so-called public trust doctrine applied, the application of the public trust doctrine to water. That's been done since 1996. It's been done in a series of cases, so it's not just one case. It's been repeatedly used. The idea came from a similar framing in the 1980s in California that we know because that was referred to in the 1996 case. And what is it that that idea of public trust doctrine does is to tell us that water is meant to be a commons, that there should be no appropriation either by the state or individuals, and that there should be a prioritization of conservation over use. So essentially everything that we have not had in terms of the development of water law over the past 150 years. So it's a complete change of perspective, which is sought to be undertaken here. Now, where have we gone since 1996? Not very far. One reason is that the public trustee was supposed to take charge of the public trust is the state, and essentially we've just asked the state to completely change the way it engages with water through a single judgment. That's very difficult to undertake. And now one of the reasons why that has not happened is because no water law has been amended to reflect that new understanding of water, and no new law has been introduced to reflect and take forward the notion of public trust. In addition, in some of the later judgments, the courts have not abided by their own very strong framework of 1996, condoning some exceptions in the name of development or individual appropriation to the idea of public trust. So, but that probably we can understand because it's such a radical change that it cannot happen just through the courts, and probably it cannot happen at one go without going through probably some different steps. Now, just to finish, okay, I'll take a few more seconds of my 13 minutes. At the international level, what do we have? Well, we have very little in terms of water as a commons. States have jealously guarded their so-called sovereignty over water. They cooperate only around transboundary water courses, if at all, in the name of a principle of equitable and reasonable use, but which is really structured around, first of all, the idea of sovereignty. And to confirm this in terms of groundwater, so transboundary aquifers, the limited rules we have, which are only draft rules, that's all that the international community has managed to come up with until now from 2008, specifically says that states have sovereign control over the part of the aquifer under their control. So there is really very limited willingness to move forward. At the level of water generally, so not water courses, which is the only thing where there is really a limited amount of cooperation, not water. Water, there's been essentially no reflection in terms of water as a commons at the global level. The exception maybe, or maybe the starting of a trend, is that report whose cover I've put 3 on the slide from the Global Commission on the Economics of Water, which possibly is pushing towards the recognition of water as a commons. But as far as I understand, it's probably something that will happen in the same way that we've had at the national level, where water in its so-called natural form is something that is beyond ownership. But as soon as it is transformed, let's say you put it in a bottle and you seal the bottle, it's not water in its natural state anymore. You can appropriate certain rights. You can assert certain specific rights over it. I'll stop here. Thank you very much.
Thank you so much, Philippe. Right on time, actually. You were right on time.
Okay.
Thank you. I'm not going to make any remark at this moment, as we want to finish as soon as possible both the presentations, so that we can have wonderful engagement with all our participants. Before I invite Sachin, I would also like to thank all our participants once again to join here, making these conversations meaningful. And also, I'd like to inform you that we run the longest water conversation with more than 325 sessions so now. And all the water scholarship is available as an open access. So do tune in and check our water knowledge available with more than 500 speakers who have already spoken on our platform. So coming back to the session again, Dr. Sachin Suresh Chandra Warghade is currently chairperson and assistant professor at the Center for Regulatory Policy and Governance School of Habitat Studies, Tata Institute of Social Sciences, TIS, as we know, Mumbai. Sachin has been involved in policy and regulatory analysis, advocacy, research, and teaching for over 2 decades now. He started his career with leading policy analysis and advocacy group called Prayas in Pune, and later he joined professionals and academic researchers to develop and implement the master's program at the TIS Mumbai campus, which he is now heading. This is also first of its kind cross-sectoral and multidisciplinary academic program on regulation. And I mean, who better than him to really give us some insights from the grassroots also. I heard him recently at the Commons again, and that's why both the speakers are here today. Sachin, back to his bio, apart from numerous research and publication, he has been instrumental in some of the highly successful public interest petitions and submissions, As a member of the Planning Commission subgroup under the 12th Plan Working Group, he contributed to the development of the model bill for state water regulatory system. And I'm really keen to hear from him about the Maharashtra Water Resource Regulatory Authority, where he's been actually advisory and consultative member. He's awarded a doctoral Fulbright Fellowship and worked in the social systems design at the Washington University at St. Louis, USA. And we also that way share the Fulbright Fellowship together. Sachin, I just came to know this week that you are also a Fulbrighter. So welcome to my fellow Fulbrighter on this session. And
Thank
over to you,
you, sir.
Sachin. You know your
Yeah.
time frame.
Yeah,
Please go ahead.
I'll start with the slide. I'll share the screen. Okay. So is this visible? Good enough?
Yes, good enough. Please go ahead.
Okay, okay. Yeah, thanks a lot for this opportunity. And as it was mentioned, I'll focus on the case of Maharashtra. So Philippe mentioned about water commons, and if you look at the state of water today, we have moved far away from the idea of commons to the extent that some of the laws in India, especially Maharashtra, has started talking about regulated water markets. So we are moving towards a very different arena. And in some instance, we also need to see how we can reclaim some of the commons principle in the new scenario that is evolving. Because I believe if you look at our drinking behavior, so if I ask you how do you drink water, it might look like a simple question, but it goes very closer to our understanding of water, whether water is my own resource, private resource, or it's a common resource which I might have to share with others. So this is very personal to us. It is a cultural expression of how we also drink water, which brings the idea of commons very close to our understanding that water is scarce and I might have to share. So if you look at this picture, beautiful picture from Junnar, so it's a river. So what do you think? Whose water is this? So if we look at the idea of water body, naturally it's a natural resource, and so it is owned by everyone, or rather it is everyone, as Philip said. So nobody owns it, so anybody should be able to use the water. But as we all are aware that we hardly have rivers which are naturally flowing. So even in Maharashtra, which is one of the biggest dam builders in India, that is in Maharashtra state has the largest number of dams, large dams. So this is actually a backwater of the dam, Manikdo Dam. And then there are distribution network. Now the whole nature of water changes. The notion of looking at water changes, because now it is an infrastructure dominated service that is being provided. But this is an actual picture of the tribals in the catchment of this reservoir. And if you look at from their perspective, the reservoir is nothing to them, because they will not be able to access as much water as probably the downstream users of water, like the industry or the urban areas. So this is the beginning of the understanding of water as far as many states in India is concerned. I'll go a little ahead. We may come back to this, how it got enclosed. But this is the new entity in the water laws, which is the Maharashtra Water Resources Regulatory Authority, which came in 2005 in Maharashtra. And if you look at the preamble of the authority and the act, it makes a lot of sense, at least in the preamble, that this is the authority to regulate water resources to ensure judicious, equitable, and sustainable management. So, who would not like to have these progressive principles and regulation on based of this? But if you go deeper, you will understand that this act is actually ushering a new era in water allocations in form of entitlement. So as Philip rightly mentioned, that this is more to do with the determination of water rights for users in form of entitlement. Now, these are again use rights, not ownership rights, but it is as if the state, which is like a public trustee, which has enclosed the river for building dams and canals, is now saying that, look, this water I'm going to allocate to individual users in form of entitlement. Okay, to that extent, it looks good because it looks like a water rights regime being created. But if you look further, the rights regime is a property right regime, and which actually gives rise to the idea of water market, because these entitlements further are allowed to be transferred, bought and sold in a market system. So this is in line with the global discourse that water needs to be treated not just commons, but not even a social good, but as an economic good. So how we convert this water resource into an economic good and bring it in a market system. So this is the first of its kind legal provision. So this is not a water policy. This is part of our legal system. Now, has it been implemented? Then there is a mixed response to this. For example, as far as entitlements, they have been working on it for several years now. There is not very successful result out of it, but there are pilot projects taken up. So even if you look at the 2011-12 data, because we don't have data after that, it says that this is the delivery of entitlement. That is how much of water was delivered as per the entitlement, that is as per the allocation. So even if you consider that at least water should be allocated as per the entitlement 100%, the number of projects and the cumulative percentage will be very less. It is 50 out of 246. So not even around 25, you might say. And if you look at the percentage entitlement deliver, that is also almost 1/3, because if you look at this 100% delivery, it is just 10 out of the 32 instances. So even with the regime of property rights or entitlements, the success is not enough. But on the top of it, what we observed was a very different process, which we termed as water grabbing. Now, grabbing is a phenomena studied even with the Marxist framework around land grabbing. So how the disposition happens over resources. Now, this is a very different type of water grabbing. I won't say it was between the tribal communities and against the others that we saw earlier, but it was between certain water users. For example, what happened was, so I will show you a picture because this depicts a bit of the process, that the water which was earlier allocated for irrigation was being reallocated for urban and industrial users. So this is a picture by a journalist because they carried a story, and then this was there was an advocacy process built on this, because the farmers are a vocal advocacy groups here also. So there were a lot of activists, a lot of civil society organizations which came together to oppose such kind of water reallocation. And this water reallocation was happening, for example, this if you look at this process, it was happening in the period of 2007-11. So that means the MWRA Act, the regulatory act, was already in place. So the question was whether the state or the state machinery can actually reallocate by ignoring the Water Act, which was already in place, because the Water Act talked about equity and other principles. So you see some kind of, again, the whole idea of politicization and using water as a political resource rather than natural resource. So this is the extent of water election that happened. Almost 2,000 million metric cube of water being reallocated from irrigation to non-irrigation use. So the beneficiaries were industries as well as big urban agglomerations. And the peak period was 2007-8 because it was a period when the High Power Committee, which was headed by the minister, was very actively looking at proposals and industrialization. So you should also know one more context, that Maharashtra was also one of the first state which kind of went against the national policy of water allocation priority, because in the national policy, it was agriculture and the second priority, and domestic water use is the first priority, and industry comes third. So wanting to become very progressive industrialized state, in Maharashtra, they gave second priority to industry. So industry got prioritized over agriculture. That is more than the food production or agriculture production. So this was also in this context that this water reallocation happened. Now, of course, because of the advocacy effort, some changes were undertaken. So one of the change was at least the priority was again restored back. So agriculture now remains the second priority and industry is the third priority. Now, so hence we took up this study further and try to understand whether this whole water reallocation from irrigation to non-irrigation has stopped or has it reduced. So we have been collecting some data. So this is the post-advocacy data. So two of my students are also in the as an audience today. Shruti and Yash has contributed in this data building process. So if you look at the data post 2014, when that policy change happened and the some amendments in the law were undertaken, still at the realm of the cabinet ministers. So cabinet minister has now have the jurisdiction over water reallocation. So they actually demoted the regulatory authority. They took away the powers of the regulatory authority to decide sectoral allocation. So after that also we have been seeing that water is being reallocated. Maybe the extent is less. Now this data is not up to date because we are still compiling some data. It is not complete in that sense. But the only point to show this data was that the reallocation is still happening. Maybe the extent has reduced. Now the current data shows that it is around 900 million metric cube. So we still need to look at this whole idea of water reallocation and from the lens of commons, that how we should share water. Now, one very interesting case that came up, and then I will conclude, is suppose you have, let's say this is a map of a basin. So this is a dam called Ujjani, and in this dam you have a reservoir which is providing water to the a drought prone area in Maharashtra, because this is close to Aurangabad, which is less developed. Aurangabad city is developed, but the water is provided for otherwise the drought prone area. So which was a commendable effort at that time. But the problem is now, even after the dam came, let's say in 80s or 90s, there were more dams that were coming up in the upstream. So if you see these small black dots, these are newer dams that were coming up after this dam was built. Now the question is, what happens to the sharing of water between the upstream and the downstream? Now, one geographical aspect is this is close to the Western Ghats. So this is actually the ridge of the Western Ghats, as you might know. So naturally, if there's a rainfall, you have a monsoon coming, naturally these upstream dams will be filled first. And as the rain recedes, because this is a rain shadow area to say so, so you have lesser rainfall. So if let's say rainfall is, let's say 60%, so that is you have a below normal rainfall. Now, if you have a below normal rainfall, naturally the upstream dams will have 100% water in their storages, whereas this dam might have maybe 50%. Now, the question is that naturally, because you are upstream, you have the dams. So as per the state authority, they will get the 100% water and the downstream will get 50% water. Now, very interestingly, in the same act, MWRA Act, there was a provision which is now we call it as equitable sharing of distress, that in case of a distress, the provision says that the water should be allocated equally among the upstream and the downstream. Now, this became a very radical in a sense, because if you look at the dam system, so this is actually the map of the dam. Can you see so many dams in the upstream? Whereas this is the dam we were talking in the downstream. Now, naturally, these are the people who would have appropriated that water, isn't it? That they will get the first right over the water. But now the law is saying that even if you have 100% of the water, you need to give up this water to your neighbors, downstream neighbors who have a more distress. They are facing more scarcity than you. So you give up your 50%, to cater to the downstream. So this is a very interesting thing came up in the same law. The same law which was talking about water market, the same law, because of certain efforts, I've done study of how this provision came, because of certain efforts of the water activists in that area, they were able to integrate this equitable sharing of distress in the very act which was talking about water market. So you can see both equity and the market mechanisms are fighting with each other in a sense. And if you look at today, this has not remained on paper over the years. For example, one of the first drought was in 2013 after this act came. There was a process, it didn't happen very easily. People had to again raise their voice, go to the regulatory authority, go to the High Court, and only after after this whole legal and regulated negotiation, that which we are calling it, after all this process of regulated negotiation, the authority accepted, and there has been a now automatic mechanism of releasing water from the upstream to the downstream. And this is some of the preliminary data on how much water has been reallocated. That means this is the amount of water that the upstream has sharing with the downstream, because the downstream is under distress. So this is also one way we can look at the modern system of our infrastructure and canal system, where water commons can be reclaimed with certain efforts using the existing laws, as also Philippe has mentioned about some legal interventions, or maybe using regulatory authorities. For example, here we are talking about a quasi-judicial authority. So this is not a full court, it's not a court, but a quasi-judicial authority. So anybody who is aggrieved or who has a concern about water sharing can go to the regulatory authority and try to invoke certain principles, of course within the law, but also applying certain principles. So because see what happened in some of these legal cases is we need to also expand the authority's vision about water principles. So that is what also is possible. So even if you are an expert, even if you are a water activist, even if you are a concerned citizen, we should be starting using this spaces where we can probably try to reclaim our water commons. So with this, I think I will stop so that we get more chance to discuss and deliberate and have a conversation.
Yeah, thank you. Thank you so much, Sachin. I will request you to close your presentation slide. And wonderful, I mean, from looking at the commons from a national perspective through the laws as Philippe presented, and then interesting case study where we are looking at how regulations can be also negotiated to reclaim the commons. I mean, the whole idea of commons. Interesting. I will invite Vaishnavi, Akila, to take up the conversation further. And before that, let me just quickly take you through her biography. Vaishnavi Akila is currently working as an educator and a youth and engagement specialist. She's based in New York and works at the intersection of global citizenship, environmental education, and youth leadership. With her academic focus on environmental justice and sustainable development, she designs and leads programs to increase policy awareness and leadership skills among youth population. Additionally, with a master's in environmental conservation education and a specialization in the United Nations, she is member of youth constituencies like the UN Major Group of Children and Youth, and where she is part of the climate security, human rights, and climate finance working group. So, Vaishnavi, now you have I will say a platform where you can look at the real-time scenario, what's going on with the rights, what's going on. I mean, youth are still far from it, but at least the rights of the people and how they exercise it to be called as water as commons. So I invite you to pose your questions to both the speakers. You may please mention who you are asking the question to, or if it is for both. Meanwhile, if there are questions and comments from any of the participants, you are encouraged to put it in the chat box or raise your digital hand. Vaishnavi will engage you also in the conversation. That's your task. Over to you, Vaishnavi.
Firstly, thank you so much, Mansee, for calling me back to Wednesdays for Water. I really love the sessions, and I really learn a lot, especially while it's so easy to get disconnected based on a lot of information that we have. There are a lot of things going on everywhere across the world, but it is nice to listen to people who are actually experts and are working in the field for many years and also seeing the progress that's happening. So also, Dr. Philippe and Dr. Sachin, thank you so much for your presentations. I really enjoyed them. And I have a lot of questions. I'm pretty sure our audience also, they have a lot of questions. So before we get in, I wanted to start with the international frameworks and national, and then move into local and community, if that is okay. So Dr. Philippe, since you are an expert in the international and national framework, I would like to look at how, with in the current times, you see that a lot of things are going towards different directions, and we see growing polarization in the global law and policy spaces. So, and now, because of that, a lot of policymakers and lawmakers are also facing challenges in terms of research and development and negotiations. And while on the other hand, our scientific bodies, like, for example, the IPCC teams and the reports have given clear warnings about how we don't have time to think about climate, and we just need to move towards action. And in keeping this in mind, what would you consider the best practice or practices for policymakers and civil societies to ensure we don't lose a progress on water policy, or even move towards more transboundary environmental protection in terms of laws and policies?
I guess the starting point for water is that we can't be talking about keeping the momentum, because there is no momentum, which has been the problem, which is still relatively surprising. Just like nobody has really managed to explain why the human right to water was never enshrined in any of the basic human rights treaties in previous decades. It remains difficult to an extent to understand how global understandings of water have not emerged in terms of international negotiations, either from an environmental or from a water specific perspective, or in fact from any perspective, because there is probably more policy or at least research arising from, let's say, WHO concerning water than, since you're mentioning the climate change regimes, than in the climate change regime. In the climate change regime, it's only very recently that water has come to be understood as something that really needs to be integrated. Until for the first, 25 years of the climate change regime, it was just an appendum somewhere. It's not that nobody would have said it was not relevant or important, but it was never given central importance. So the answer is probably that we need to build an understanding of the importance of water as a commons at the global level, which is not there in terms of policy making yet, and then move on from that in terms of the so many different directions and elements that will be affected. So climate change is just one of them. It's a central one, but it's just one of them.
That's really interesting to think about water in that way. So keeping that in mind, the idea of global platforms, this year we have COP30, one of the most major, as they say, climate conferences, where you see everyone going and trying to talk about it. Like every time they're going to review the progress and the NDCs as well as discuss them, but there's barely any light put on food security and water security. And it is growing, especially in countries which in the global south that they say, like India. Conversations right now also revolve around net zero and green economies, but it feels like they constantly separate the protection of natural resources and economic policies from the environment. So does this separation in the international space play a role in the national policies in countries like India?
One of the things that's very clear is that the importance of water at the national, the lack of importance of water at international level has nothing to do with the immense importance of water at the national level. In India, water policy and law has been central for decades for any government. For obvious reasons, it's a question of political survival. If people don't get access to water, it's also a question of survival as long as the economy is agricultural based, which is possibly less the case, but there are other industrial or developmental needs that also need a lot of water at this point. So it changes, the system changes, but the importance of water does not diminish. So there is probably no comparison that we can make at this point. But the problem is that there is a refusal, and that's nothing to do with any single country, as far as I'm aware. It's really every country doing the same, wanting to believe that they can limit their understanding of water at their own national borders. And that comes from the idea that the only thing we need to compromise on a little bit is with regard to transboundary water courses. Those ones we all know we can't affect, as in we can't direct the flow, especially of very large rivers. But there is no understanding, as in the scientific understanding is there, but there is no policy understanding of the fact that typically climate change is completely changing rainfall patterns, which we know on the ground so well, and that this in itself is something that needs to be considered as a global issue in terms of water. I think one of the reasons why that has not happened is because it's such a sensitive topic that it will be very difficult to come to any compromise, but in a context typically of cloud seeding, which now can probably affect moisture from one country to another, or other patterns apart from the global dimension of climate change. There may be an increasing willingness at some point to at least start addressing some of these broader aspects, whether regional or international.
So I'm also assuming in this case, we could also look at regional corporations playing a huge role for water policy than the global ones. So keeping in mind the national policy and national level, one of the biggest challenges that I'm aware of is the data. For instance, our last census was in 2011. And since 2011, we have seen some major changes happening, including population growth. We saw a global pandemic, then there's increasing desertification, and also development of technologies like now we have AI. With this in mind, how do policymakers at the national level navigate through data challenges?
Okay, data challenges per se, maybe I'm not the right person to answer, but data in terms of providing the basis for water policy making, that definitely is an issue. But the thing is, water is so many things in so many different domains that certain domains will be more affected by, let's say, the delayed census than others, which will be more reliant on technical data that may be needed for policy making. Okay, one of the things that we probably see is that policymakers are influenced by data, but they're also influenced, okay, let's say national level policymakers in most countries are influenced by data, but they're also influenced very significantly by mainstream policy debates and the direction that these policy debates take. So at a certain level, sometimes one gets a feeling that those global debates seem to be at least as important as the specific data one may see at a more specific level, and which is reflected in the fact that many countries around the world are following relatively similar types of water policies, despite the fact that water is typically one of these things where every country is facing its own challenges, and within countries, we can say the same with in this case, every state, every district, and so on.
Vaishnavi, you are on mute.
Yeah. So we have a question in chat related to data from Mansee. So of the identified 200,000, only 200 wetlands are regularized. So is that also a data challenge or data problem is what Mansee is asking.
I'm sure it is as well, but I'm afraid I don't know more specifically.
Okay. Dr. Sachin, do you have?
Yeah, so see, 2 points I would like to comment on you raised earlier. So I think the whole idea of polarization is quite an important phenomena because one might say, okay, what is its relevance to the local water issues or state level? But we also see that the overall polarization on different grounds, whether it is economic, class, caste, religion, has also its impact on at the local level because for example, in this case of Ujni that I was presenting, so making people realize that water has to be shared, the distress has to be shared. So it's not just having a legal provision, but getting that sense of solidarity between different water users, which have a contrasting claims on water, is a challenge in itself. So, and you rightly said the level of polarizations that is happening currently. How do we address that? So actually, when I felt about this whole water commons talk and the conversation, I think this should be now on the top for all water experts because commons is such a powerful idea which we need to embed. We could draw our ideas from maybe, as I said, cultural practices, religious, whatever you want, but we need to connect with that idea of water as commons, as part of nature, as against water as just a service. So we take water as granted because I'm getting water, but I don't know I'm grabbing somebody else's water. So water grabbing is not just a political phenomena, but we all individual are grabbing somebody else's water. So how do I bring, even in case of data, for example, what kind of data is relevant? So today, lack of data, lack of governance, lack of even regulatory oversight is also creating a discretionary system. So you don't know, as you know, one of the author in groundwater said, Tushar Shah, he said it's all anarchy. So not only groundwater, but even surface water, although there are regulations, laws, but on ground, if you see, there is some kind of discretionary systems at work, and that is helping the dominant sectors, dominant sections to assert more and more water. Because as soon as we start talking of water grabbing, we expose the data, then the attention comes. So nobody wants the data. So nobody wants the data to be, made public or given, coming out, because then the iniquities in the water allocation will get out, and then it will be very difficult to handle some of the governance issues. So data problem starts right there. So it has a political economy of its own. For example, one of the major challenge in India is, even if we are talking of water laws, even if we're talking of sharing it equitably, we don't have data of how much water is there, who is getting what water, how much water everybody is using. So measurement of water, that is the measuring devices basically, whether it is on the canal, on the river, or wherever it is, we are not able to measure water effectively as we measure other things. For example, energy, electricity, now is sorted out based on the regulatory system, but water is still remains unsorted with whatever its political economy is. And that is a big challenge. So today, actually, when we are talking here, commons is such a deadly idea, such a powerful idea. And I think we should stick to it, try to work more on it to ensure that we reclaim various spaces for commons, even if it is of data governance, that how we can bring more data. For example, the data that I was presenting, we could collect it only through RTI. It's not available in public. Some of that data was not available in public. Some of the data is available, but some of those documents are completely out of reach for common people. So these are some of the challenges that we need to address. Yeah, thanks.
Thank you, Dr. Sachin. That was actually, it's bringing on light to the gaps that we actually have at different levels of policy making. And now on that note, I wanted to ask both of you that we talk about rivers in India and there's a lot going on there. And considering we are also agrarian, for this, preservation and conservation becomes extremely necessary, along with strong regulations of how we use our commons. So in that context, how do our national policies actually interact with our states? We saw a glimpse in what Dr. Sachin presented already, but I also wanted to know, is there any level of interaction with the states where we see especially between states who have political tensions because they have shared rivers or shared commons?
Nice question.
Okay, so fine. I'll
ahead.
start with something. Okay, you just said strong regulation. I vaguely suspect that there is a lot of strong regulation that already exists at various levels, state, interstate, national level. But because we are talking about rivers, whether it's those super large rivers like Ganga or some local river, all of these rivers have a very local dimension. And if there is a reality to water as a commons, it starts from the local level. That the world has been saying for decades that the commons, the discourse starts at the local level, but the legal frameworks are completely away from that. So the starting point is not so much, I mean, maybe it's also better enforcement of what we have, better implementation. But if it's about rethinking water as a commons in terms of the law, then it has to start from a local understanding, a multi-level understanding that looks at how the different local, let's say, tributaries build into a larger river, and how these different conservation, protection, use measures at the local watershed level can be linked, can be coordinated, and how they can translate into state level policy, and then if it's a national river, into national level policy. For the time being, everything we have has been the other way around, starting from the top, maybe going down, but it gets lost in the going down level, which means it's a local level, which is given the least importance in a way, whereas if we are really to do something effective, it has to start from the local level. That I guess is true also in most countries. There's been a lot of emphasis when we talk about rivers, we talk about the stem, the big river, what's visible, and the big river, typically in the case of Ganga, where so much effort has already been made to clean it. The basic reason why it's not yet clean is because you can't do only the main river itself, but you have to do everything else, which is such a vast enterprise that cannot be limited to the main river itself.
Thank you for explaining getting Ganga into, because Ganga is shared, it's one of the largest river and it's shared between states. Dr. Sachin, do you have something to add on to that?
Yeah, so see, if you're looking at commons from a national and a state perspective, see, it looks like a utopian today. No? So because, see, who is demanding the commons? Because once you say commons, it's almost like a very radical thought today. Because it will lead to, it means that water needs to be reallocated. That is, someone who is using water so much today needs to give up their water to somebody else and then make it as a common resource. So it is going to disturb the status quo. You know, if you try to integrate commons into your legal principles or legal this thing, and which actually we should be doing, and wherever we find small spaces we should be doing, or how we can strengthen the people who are dispossessed or people who are disadvantaged in the overall water allocation scenario, so that they can demand or reclaim some of the common principle. So the process will be quite tedious to look at commons, and it's going to take a long period. But I think as you were connecting this whole thing also to the overall global problems of climate change and all that, so as the crisis level goes on and on, like we saw in the case of this Ujni and Jaikwadi and all that, as the crisis increases, the stakeholders will start demanding something else, and that is where the spaces for reclaiming some of the lost ground on commons could be there. So the emerging crisis has a potential also within that to probably look at water in a different way than the way we are looking at. So fortunately, this failure of entitlement, failure of market is important, because that means the prescription-based rights, that is the rights based on some prescribed norms, is not working. So which is a very, as Philippe rightly said, it is an essential property of the water that defining rights is not going to be so easy. So that means it is going to be through some negotiation process. It is going to be through some community process that we determine what exactly is the nature of water, and then how to address this issue of allocation and reallocation. Yeah. That is what I think.
Mansee, do you have something to add on?
I'm really enjoying this conversation. Reminds me of almost the mother of commons, Elinor Ostrom. And I remember 2009, we were sitting in a conference at TU Delft and we were talking about deregulating the common pool resources and the very idea. So I will actually have this as a question also to both of you. That year, TU Delft was giving them honorary doctorate to Williamson transaction cost theory and Elinor Ostrom for the commons, and they were already Nobel laureates that time. What do you think? I mean, you both have had made it very clear that it has to be bottom up if the moment we talk about commons, but at this moment it is pretty clear that it is top down. And we are also seeing the challenges and tensions in having the top down, be it cleaning of the Ganga or be it looking at the Jayakwadi or MWRRA Act. I mean, I remember my student doing a thesis on, I told you earlier also, on this whole little check dams and the rights of every riparian edges, you know, what happens. If it has to be bottom up, do we have the regulatory system or experts to really help us unpack this whole system, which is right now so top down? And then if it is really about deregulation, how do we really think about the principles of deregulation? I mean, I know I'm talking utopia. Probably some people may even say that I'm moving too much towards Marx. But why not thinking something different? As Sachin, you rightly mentioned, if it is not working, there is no harm thinking it in a different way. But who is going to sit at this moment? Scientists are not part of the regulatory system most of the time, apart from, of course, advisory and committee. And I see some level of informal deregulation in the way farmers protest, in the way people really seek their rights through the legal ventures. But I just want to understand through you as last words, probably. And if there are any questions, I would like to really take from participants also. It's very rare that participants are not engaging in these conversations at Wednesdays for Water. Maybe we can invite two of your colleagues, Sachin, who you mentioned in the beginning. They can also chip in with their little bit insights. But meanwhile, they ready their question or comment. What will be few design principles if we have to go the deregulation way? Who wants to go first? Philippe, you first, and then maybe we are taking the same order in all questions.
Yeah, so Sachin was already
Yes, go ahead.
unmuted.
A difficult question, yeah.
Okay, deregulation.
Or am I wrong?
You're saying deregulation or re-regulation?
Deregulation. Deregulation.
Deregulation.
Because, I mean, see, we are already highly regulated in the top down. And these maneuvering and manipulations are already trying to find a way which are kind of a symptoms of deregulation in some way. But I'm thinking extremely extreme, you know. Let's say that water as a common is our national goal. How do we now envisage it? What are the design principles?
But okay, one of them that's been in discussion for decades from two completely different perspectives is delinking land and water rights. So in one direction, it's from an equity perspective to say that typically the landless have no rights in the current system. Okay, they have a fundamental right to water, but otherwise not those more concrete physical rights. And from another perspective, the same push or pull has been proposed by pro-privatization in a way pro-market actors, saying that we need to delink land and water to be able to trade in water separately from land, because the value of water has increased much more than its value in relation to land. Again, the idea of linking land and water in the first place was because for sure it was related to using the water for agriculture or for some form of agricultural use. So we don't have that anymore so much, so we can move to something else. Now, interestingly, in terms of regulation, deregulation, is that the argument for allowing for allowing market trading has been in part that there has been no rights to water, therefore we need to introduce new rights to trade in water, which from a legal perspective is completely untrue because, okay, that's what I tried to present before, particularly with groundwater, they have very strong rights. The problem is that they're not enshrined in statutory form, so they're not visible so easily to the non-lawyer in a way. But so it's very interesting that the deregulation, in a sense, if we are taking it in this way, the deregulation discourse is in fact linked to yet another form of re-regulation, because you can't trade in water without some form of property rights. So I'm not sure that even when deregulation is proposed, it goes only towards a free for all. And mostly water as a commons has not been conceived as free for all,
Yeah,
but rather
very well put.
regulation at the community level, or different types of regulation.
I think there comes the role of self-regulation, which has been our traditional water management system. But then when it is upscaled, I think the scenario changes, because most of the streams will be considered transboundary, whether it is inter-district, or most rivers will be transboundary, whether it is interstate or international, gets into the hydrodiplomacy scholarship. And these scholarships are very much there. I mean, Sachin and Philippe, both of you, I also wish to share with you the idea of resource grabbing. 2 years ago, we had a very good compilation of resource grabbing, where I actually looked at the water grabbing from the urban perspective on making river fronts. So, and now looking at the water grabbing scholarship, which is still way far behind the land grabbing scholarship, I think there are more scholars required to work on it. Because when Philippe is talking about delinking, I'm already looking at what he was also mentioning. You still needs another set of regulation, and I think, Sachin, you can also highlight it more, looking at what Ostrom has worked on self-regulation. Where do we stand there today? Because we were very self-regulated in the past.
Yeah, I know. So see, I mean, we need to make a distinction that if we are
Yes.
going to say deregulation, it might be possible in certain water bodies which are still untouched, or or not appropriated. But if you look at the water system in India, most of the rivers are appropriated. They have been used.
Yes.
There are closing basins, and especially peninsular India, you won't see any now extra water available. So how are we going to deregulate? Because then it will mean that the appropriation will still continue. So in fact, I would suggest we need a re-regulation, and that's why I was asking.
Yes,
And
very well put.
exactly. So re-regulation with the sense of bringing the communities which have lost out their rights. They have been dispossessed. They have been migrated somewhere else. So how actually we can re-regulate to bring the principles of commons? Now, see, one of the challenge that we are dealing, and we are trying to write on this is, and when you mentioned this transaction cost economics, and because that's the main challenge, because the
Yes,
market
that's why it's not happening.
the market mechanisms are giving us a challenge that do you have an alternative? Because they are claiming that this is our alternative. Because of the transaction cost economics, market is a better mechanism to reallocate water or allocate. So what is our proposal to reallocate? That how this whole process of reallocation will happen? Will it again go back to the administrative allocation or political allocation? Or, as we are suggesting right now, we are trying to learn from Jayakwadi and these cases, that whether this can be looked as a regulated negotiation process. That is, because anyway, you will have to come across for some negotiation, and negotiations cannot happen in vacuum. There will have to be some regulatory backing, some policy backing, so that creates some space for regulation. Otherwise, today the dispossessed do not have the political power to bring people on the table of negotiation. So how actually re-regulation can help to create spaces of negotiation within a regulated ambit. For example, the regulated authority played an important role. They formed an expert committee to see how what is the upstream demand, what is the downstream demand, how to define scarcity, at what instance we should reallocate water, how the water should be reallocated. What
Yes.
if water is released and that is used again by the same users? So all
Hmm.
these mechanisms were evolved. So we are trying to articulate whether this can be seen as an alternative to your regulated market, because they are saying that it is a regulated market, that is better mechanism. And then if you're going to say, oh, no, but this is a common resource, we need to negotiate our resources. So can it be a regulated, negotiated process? That is what we are working on. So yes, you're rightly, Yash and Shruti is there. So if they want to also participate with some comments, they
I
can
think
come
it will be
forward.
good idea. Thank you, Sachin and Philip. I think we can go on talking about this because it's kind of our pet areas of work. So it's always interesting, but it's also good to hear from the young people. But would you like to just chip in here? Yes, Prachi? I am not hearing them
So,
and I don't see any
uh,
question in the chat box. Okay, yes, please go ahead.
no, I was just saying that I think Sir said it, explained our work very well, and we are
Mm-hmm.
also in the process of learning. So, for
Hmm.
example, this conversation was very insightful now. So currently, I don't have any comments to add.
No issues. Thank you. And keep up the good work. I think with this, I would like to call off the session today. And thank you so much, Philip and Sachin, for your wonderful insights. And definitely thanks, Vaishnavi, for bringing up some questions. Although sitting at New York, you could still feel the land here and bring us some naive questions as well as some intelligent questions as an ordinary citizen, which is the role of the discussant, that you become our representative on this platform. So before I say goodbye to all of you, I would really like to once again thank all the participants here who are here, and also I see some of them also watching us live on YouTube. We thank you for your support and encouragement to make these water conversations meaningful. We shall continue with Wednesdays for Water as well as other sessions. So here is an announcement for the next Wednesdays for Water session on April 2nd, 2025 at same time, 5 p.m. IST. We have never changed the time usually unless and until our speakers are somewhere in Canada or far or Australia where we had to change time. Next week on 2nd April, we talk about serving a pipe dream, water supply in the metros. And we have some wonderful speakers again, like today, to speak this interesting idea. This week, we still have one more session to go on March 28th, which is Friday. That is, we have Friday Water Talkies. So on Friday, we have some interesting alternate ways of looking at water as a subject of study and even enjoy. So we have the film on Satyagraha made on the Jal Satyagraha done by Matri Sadan Haridwar. And this film is also already documented a long time ago. And we are going to have a conversation with the director as well as Guruji from Matri Sadan, Swami Shivanandji, who will be seated and will talk about his Satyagraha on saving Ganga. So do stay tuned, and we will shall continue, and we are constantly looking for speakers. If you know somebody who would like to speak on our platform and be part of the W4W family as one of the longest water conversation, as well as a consortium of speakers, please stay tuned, stay wet, and take care of yourself in this summer. And see you Friday or Wednesday soon. Bye-bye. Take care. Thanks a lot.
Thank you.
Thank you. Bye-bye.
Bye-bye.